Welcome everyone. I'm Vitada Anukumataka. I'm your host from SCAP's Trade Investment and Innovation Division. Today is our second workshop in the series. This workshop is part of the webinars that we organize under the projects of global hackathons on AI for digital trade regulatory analysis. We have a pleasure to have 4 experts today. We have leading digital trade law professor, Professor Henry Gao from Singapore Management University, join us. And we have Achik Solomayan from the WTO joining us. We also have Kun Sarut Tipsena from Stelligence. And we have 2 experts from European University Institute, Thomas and Simon. Today we will learn from their experience because all these experts has been dealing with real world context of digital trade regulation problems. One of our key experts is also really build the solutions to help the practitioners solve the complexity of digital trade regulatory analysis. Without further ado, because we have so much to learn from our experts today, I will give the floor. But before that, I would like to say that if you have any questions, please put your questions in Q&A box. It would be great if you can also indicate which experts you would like to ask. We will open the floor for questions at the end of the workshops. But for our first speaker, Professor Henry Gao joined us from Australia, which is very late at his time zones. So I will open the floor for his questions right after his talk. Henry will be our first speaker. Henry is well-known lawyers who dealing with digital trade laws and the WTO. He has been advised many international organizations, including the WTO, UN, ADB, World Bank, and we have worked with him for a very long time through many projects at UNSCAP. Henry will be introduce you to the very fundamental knowledge that really important for anyone who have to understand and address issues related to digital trade regulations. He will introduce you about hierarchy and obligations type in the law, and also showing you with real experience. I'm very excited to see his presentation. Henry, please go ahead.
Thank you, Vitada. So I will start by sharing my PowerPoint slide. So let me just put it on. Okay. So it's my real pleasure to join the webinar. I'm also, in addition to being a professor at Singapore Management University, I'm also a member of the advisory board for the Hackathon, and also I worked with SCAP in the capacity as a member of the advisory board for the TINA, the Trade Intelligence and Negotiation Advisor tool, which I think many of you probably are going to find very useful when you prepare for this hackathon. So I strongly urge you to please, take a look at the TINA, especially the legal TINA, which is available on SCAP's website. So with that, please feel free to share the link in the chat with the participants. So I have been working on digital trade issues for a long time. As Witada mentioned, actually, I started my career as a lawyer in the trading and service division in the WTO some 23 years ago when I was working on the Mexico telecommunication case, which was I regard it not only as the first services case, but also as the first case concerning e-commerce and digital trade in the WTO. So it's a real pleasure for me to share some of my thoughts on how to read domestic statutes in terms of the understanding the legal structure and the language patterns, which I think many of you will probably find useful when you prepare for the hackathon. So, as the current Director General of the WTO, Dr. Ngozi likes to say, the future of trade is services, is digital, is green, and it should be inclusive. So, digital trade has become a key component of the world economy today, as we can see, with things like, for example, the single-day, festival in China, which draw in, a huge number of transactions every year. And with other countries, we also see that there is a growing interest and a growing market in terms of digital trade. So digital trade is becoming a more and more important part of the global trade today. Now, with the rise of digital trade, we also see the proliferation of digital trade legislations across all kinds of countries in the world, right? So, in some of my previous work, I have discussed the defining features of some representing jurisdictions when it comes to digital trade regulation. So, if you compare the three main players in digital trade, for example, the US, China, and EU, you find that some of them tend to take a more market-oriented approach. Some of them tend to take a more state or security-oriented approach, while some tend to take a more consumer or privacy-oriented approach. So this resulted in a variety of legislations that regulate the digital trade. And invariably, this would lead sometimes to the conflicts between different regulatory regimes. And therefore, there's increasingly a need for better coordination at the international level, because otherwise it would be very hard for countries to trade with each other. So, how do we regulate digital trade at the international level? This is where things such as free trade agreements would come into play. So, we have seen the rise of free trade agreements that include chapters in digital trade issues in recent years, as pioneered by the United States in its trade agreements. For example, the first trade agreement that included a provision on digital trade was the U.S. FTA with Jordan back in 2000, some 26 years ago. And these free trade agreements do provide some interesting models of regulation and also international cooperation and coordination when it comes to digital trade regulation. But they are fragmented in the sense that they tend to be mostly bilateral. So in recent years, we have seen efforts to try to further improve the harmonization of these rules. And this led to initiatives such as the Joint Statement Initiative in the WTO on e-commerce negotiation, which was concluded 2 years ago, and which resulted basically in first major international regulation on e-commerce at almost the global level. It does include all the members of the WTO, but it can include almost all of the major players. So we could see that this is almost the first major global deal. And I think that would also provide a lot of inspirations to many of the teams as you prepare for the hackathon. So for today's presentation, I would focus on the domestic statutes. And here, let me first walk you through the typical structure of a legal statute when it comes to the drafting. So typically, most of the legal statutes would start with an introduction or preamble. So this introduction or preamble would tell you why there is a need for such legislation in the first place. So this is typically couched in what we lawyers call, non-binding best endeavor type of language, because the strictly speaking do not create the binding obligations. They just explain the background, the thinking behind the law, but they provide a very important directions in terms of helping everybody to understand what are the objectives of the statute. So therefore, if you have difficulties in interpreting, in finding out, the exact meanings of a certain provisions in the statute, you can always refer to the objectives stated in the introduction or the preamble, because they would tell you which way you should interpret this specific law. And then this is also coupled, typically followed by provisions which are called definition or interpretation provisions, which basically include a list of the key terms that are used in the law, right? And the law would define what we mean by these specific terms. Again, that is very important because one thing about legislation is that we want to be as precise as possible so that the people will know what is the coverage of the law, right? What type of activities or, actors are covered. And this would really help people to guide their actions accordingly. And then after this definition clause, we would enter into the main body of the law, which would be the substantive obligations. So the substantive obligations basically tell you what you should or should not do with regard to specific scenarios. So a lot of this language would be couched in provisions which start by saying so and so should or should not do this or that, right? Or you must do this, or if you do this, then you should do something else too, and so on, right? So this is basically the main body of the law, which lay down the main substantive obligations, and this is where when you are preparing for the hackathon, I think you would spend most of the time because this would, include most of the so-called meaty provisions you would be dealing with. And then the next part would be institutional provisions. So the institutional provisions basically provide the details on the institutional arrangement. Because at the end of the day, even if you pass a law, the law cannot enforce on its own. You will need people or institutions to enforce the law. So this means that you need to put in place an institutional framework to implement the law. And this institutional framework typically include, for example, either setting up new government agencies. For example, in recent years, Many countries introduce new legislations protecting personal information or privacy, right, or personal data, and therefore they would set up, personal data protection agency that would deal with these issues, right? Of course, you do not necessarily have to establish a new agency every time. Sometimes this could be, taken care of by some existing agency, but in many cases, there will be new agencies. The next part of the law will include provisions on enforcement or implementation of the law, which basically tells you what are the penalties if you do not do what you should do, or if you do what you should not do, right? For example, again, when we talk about provisions on protection of personal information, right? So these laws typically include provisions which would state that if, let's say, a firm failed to provide personal information, then they could be fined, right? Or they could be, subject to much harsher punishment. I mean, in some cases, there could even be criminal liabilities for some of these most severe cases. So that is the enforcement provision. And another part of the law, and this related to the enforcement, is the part on judicial review, because the enforcement is typically done by the government agency. So this would be administrative enforcement. It is enforcement by the administrative tribunal or the agency. But what if the administrative agency make some mistakes? Then in such a case, many laws do provide for the possibility for judicial review, right? Whereby you can appeal the decisions made by the agencies to either a court or some administrative review tribunal that would provide a second chance, because otherwise, if you have a government agency that has a final say, that obviously goes against the basic principles of a rule of law, right? We want to make sure that there is an independent agency, right, like a court, that would review the findings of the agency, and this would help to provide some remedies to the firms when they believe that they have been wrongfully, let's say, punished by the government agency. And last but not least, we would have also many laws include appendices. So these would include annexes and which would lay down details which do not find in the main body of the law, but they typically include details that are very important for you to understand in detail what are the specific meanings of specific provisions. So, if you have a difficulty understanding specific provisions in the substantive obligations section that I mentioned earlier, I would advise you to continue reading the law, right, to go towards the relevant annexes, and many times you would find the explanation in such annexes. So to help illustrate what I just mentioned, let me give you the example. This is a real law, right? It's the Personal Data Protection Act, enacted by the government of Singapore. And I've actually given copies of both my presentation and the full text of this statute to SCAP. So please feel free to ask for copies of these presentation and the law, so that you can use that to really understand what I explained during the webinar. First, a part on introduction, right? So to the right, you have excerpts from the PDPA, Personal Data Protection Act of Singapore, whereby, as you can see, Article 3 basically explains the purpose of the act is to govern the collection, use, and the disclosure of personal data by organizations in a manner that recognizes both the right of individuals to protect their personal data and the need of organizations to collect, use, or disclose personal data for purposes that a reasonable person would consider appropriate in these circumstances. This law in Singapore actually is quite succinct when explaining its purposes, but in some jurisdictions, the introduction part could be quite lengthy. So to the left, you have an excerpt from the GDPR, the General Data Protection Regulation, which is the first major personal data protection regulation in the world that was enacted by the EU. So as you can see here, actually, before the main body of the law, they include a recital that is really lengthy, that include 173 paragraphs. So, this explains in much more detail the background of this law. And, if you are interested, you could read this. And, because the GDPR is really influential, it has become the kind of a model for many countries when they enact a personal data protection law. So if you read it, it would really help you to understand, the rationale behind these laws. Second part, as I explained, definition, right? So as you can see in the PDPA, the defined terms such as, for example, here, processing. So a key concept when it comes to personal data protection is the processing of personal data. So what exactly do we mean by processing? This clause explains that the processing include any of the following activities such as recording, holding, organization, adaptation, alteration, retrieval, combination, transmission, erasure, or destruction, and so on. So that really provide a very detailed explanation of the meaning of specific terms. Then on to the substantive obligations. So as I mentioned earlier, there are certain trigger words that you typically find when you look at these substantive obligations. So this trigger word would tell you, right, whether this provision is binding or non-binding, right? The binding provisions typically would use trigger words such as must or must not, may or may not, shall or shall not, should or should not, can or cannot. Again, an example from the PDPA, Article 13, which states that when an organization collect, use, or disclose personal data, right? The must seek the consent of the individual. The law states that they must not collect, use, or disclose data unless the individual has given the consent. So this basically means that they must get the consent first before they collect, use, or disclose personal data. There are more examples regarding the trigger language provided here, right? So another example here, as you can see to the left, is states like this: unless otherwise provided under this act, an organization may do this or that, right? And then to the right, an organization may do something and so on, right? So these are further examples that can help you to really find out which provisions are the key provisions. Next, the institutional provisions. As you can see, the PDPA established the Personal Data Protection Commission, right, which basically is a kind of a new institution, but it is housed in an existing agency that is the IMDA, Info Communications Media Development Authority of Singapore, which also doubles up as the PDPC in Singapore as to tasks for protecting, the personal data in Singapore and exercising the functions under the PDPA. In terms of enforcement or penalty provisions, again, here are some examples, right? For example, here, as you can see, Article 48K basically gives the detailed procedural rules when the commission gives direction regarding section 48 I or 48G. So basically, before the commission can issue some penalty, they should provide this information, right, in order to help the organization subject to this penalty to understand why they are being fined, and what are the non-compliance that it is about. So this really help them to understand what they did wrong and help them to remedy the situation if possible. The PDP also provide for the possibility of judicial review, right? So there's a possibility of appeal from the decision of the commission, as you can see, and the section 48Q, right? So that is to make sure that there would be appropriate remedy provided to the affected organizations. Uh, in terms of appendixes, right? So as you can see here, different appendixes deal with different issues. For example, the first schedule lists the vital interests of individuals, right? And the A schedule excluded certain messages from the meaning of a specified message, and part 9, it excluded those by, for example, public agency, right? Because the government will need to send out information, right? If the government need to seek consent every time that the government send out, information, for example, if there's another pandemic, right, then that would be really burdensome, and it's not conducive for public policy. And also message sent by individual acting in a personal or domestic capacity. If you want to send a message to your family members, you do not need to seek consent, because otherwise it would also be quite burdensome. And the law also include some cross references, and also provide the possibility for the government to issue further implementing regulations. So cross references, for example, if you can see the one to the right, basically refer to the Penal Code of Singapore, which is basically the criminal law of Singapore, because there could be some overlapping between different laws. So it's important to point out, which law apply, and also to the Evidence Act and so on. And the law also provide for the possibility for the minister to make regulations to provide for the application of any provisions of the law. So basically, most laws are drafted in quite broad language, because the legislature typically is quite busy and they cannot envisage any future scenario. So therefore, they provided certain discretion to the government agency in charge to provide further implementing legislations and implementing regulations, and such regulations would provide a more detailed, guidance regarding specific scenarios. So that would be really helpful for the future implementation of the law. So I would conclude by also direct you to the SCAP initiative on regional digital trading integration, which has this really useful index called Regional Digital Trade Integration Index, right? And the Digital Trade Regulatory Similarity, framework. So basically, if you look at this slide, you can see that they include, all these different pillars that you commonly find when it comes to digital trade regulation. And I think this could be used as a very useful pointers for you when you want to figure out, the specific laws for different issue areas, because we listed all these pillars and indicators very thoroughly. So you can go to SCAP's website and consult this information, especially for those of you who do not have much of experience in analyzing statutes. Again, with Teda, I would appreciate it if you can share the link in the chat so that the participants can copy the link for future reference. So I would conclude here and welcome questions from everyone. Thank you very much.
Thank you very much, Henry. Uh, Many thanks for mentioning RDTI, which is going to be the framework that the hackathon participants are going to cope with. And I saw one question right now in the QA box. He asks about a digital trade agreement that commits country to free data flow, but domestic regulations often prohibit those free flows of data. So the question is, how do you see this conflict resolved in the upcoming years? How effective is the international agreement in enabling data transfer?
Okay.
How this relevant to our team in Hackathon?
Right. That is a great question. I have analyzed this actually extensively in some of my writings, but let me explain it briefly here. So there is this common misconception, I think, in many countries that when you agree to a provision on free flow data in trade agreements, in either FTA like CPTPP or digital economy agreement like the DIPA, then you have to, provide 100% free flow data. Well, unfortunately, that is not how this provision should be, interpreted. Because first of all, if you look at the language of the provision itself, it states that each party shall allow the cross-border transfer of information by electronic means, including personal information, when these activities for the conduct of a business of a covered person. So this is the language taken from the CPTPP. So the first condition is that the activity, right, that is linked with cross-border data transfer should be for the conduct of a business of a covered person. And a covered person is typically defined in such FTA as a business firm providing services or conducting investment activities where the party has made a commitment. So, in other words, if you are really concerned with the frivolous data for a specific sector, right, you can decide not to include the sector in your services or investment schedule to start with. So if you do not include, this sector, for example, some countries have, really concerns regarding the cross-border data flow of, let's say, certain financial information, right? Because the financial industry is very important. So you can, exclude certain financial sector from your liberalization schedule, and then you do not have to allow free flow data, right? So that is one, legitimate way of doing it. And second, even for the sectors which you include in your schedule of commitments in the free trade agreements, you do have the possibility of invoking the so-called exceptions clauses, which either found in the same chapter of the digital trade on digital trade. For example, if you look at the RCEP, the Regional Comprehensive Economic Partnership Agreement, which Indonesia is also a member, you do find, provisions on the exceptions in the e-commerce chapter, right? And second, even if you do not find it in the e-commerce or digital trade chapter itself, typically there's another chapter which is called the exceptions chapter, right, where you would find such exceptions. So these exceptions clauses allow countries to impose restrictions for either public policy reasons or for national security reasons. Public policy, right? For example, sorry, is there somebody?
Sorry, go ahead, please.
Right, right. Okay. So public policy, for example, if the police wants to, chase down a criminal, of course, right? Then the police would need to have access to the personal data of the criminal, right? And I mean, that is a legitimate exception that everybody would be willing to make. And the national security, right? So you have a certain sensitive information, for example, the location of a key military facilities, right, and so on. This information that you might not want to allow the free flow across the border, and you can definitely do that too. So I would say that the obligation is less broad as most people tend to think, and there are always policy space available for countries even after you have signed on to such obligations in your free trade agreements or in digital economy agreements. I hope that answers your question.
Thank you very much. It's answered the questions. And for the participants, if you are worried about the conflict between those two domains, is not that much. Plus, in the framework that we give to you, we only request you to look at domestic regulations. So that's good. I don't see other questions, but I'm sure that more questions might come in after they gone through the rest of the session. So, Henry, thank you very much, and we will be in touch also with more questions that we received from the participants today.
Sure, thank you.
Thank you. Our next speaker is from the WTO Secretariat. We have Dr. Ashik Solomonian. She is the Legal Affairs Officer, and she works in digital trade and frontier technology hubs of the WTO. Ashik, could you please take the floor?
Thank you so much. Let me just try to share my screen, my side. I hope you can all see it. So good evening, everyone. Thank you so much for the invitation to speak at this panel. I was asked to present the end user perspective, but before diving into the details and to the substance, let me just very quickly explain what my presentation will aim to do. Now, legal research is just not some kind of compilation of information or of laws. As an end user, what we would like to see at the end of your research is clear, reliable, and if need be, also actionable results. Whether it will be in the form of a report or in the form of recommendations. And to get there, in my opinion, we need to have a very specific mindset from the beginning, and we need to account very clearly for all the challenges that we might have, and some of them might appear unaccounted for. So you need to be prepared to face the challenges as you go through your research. So this presentation will serve you as some kind of a checklist of items to check and to keep in mind in your research so that your result actually satisfies the users. Now, to start with, I think it's super important, as I said, to frame the mindset and to have a methodology. So when you are getting your task, sometimes it's easy because you are given the scope, you know the terms of reference, and it's really easy to understand what you have to do first and what your end result would be. But sometimes it's not the case. So sometimes you yourself need to come up with the scope, what you have, the sequence of steps, and what you need to have as a result. So please take your time to think of methodology. What is your main aim of research, whether it is a research on digital trade regulation or any other legal area? Try to formulate your main aim, main question very clearly and simply in purely one sentence. Now, if you need to take 5 minutes to explain your main idea, I would suggest you think a bit more, because at the end of the day, the more convoluted your research question is, the harder it will be to get to the very clear end result. It is important also to understand the benchmark. What are you assessing against, right? And to understand your benchmark very thoroughly. Unless you know exactly what you are looking at, it is going to be hard to compare national legislation to that benchmark. For example, there might be differences depending on the benchmark. Are you looking at an international treaty? Then you are looking at a different type of benchmark. For example, you might be asked to assess a national legislation of a country to see if the country is ready to join an international treaty. Now, for that, you need to look, for example, at the mandatory requirements, look at the national legislation, potentially look at the implementation, and come to a conclusion whether the country is ready to join, and if not, what are the gaps that needs to be rectified. The logic will be a bit different if you are looking at international best practice cases, right? So there is no an obligation. It's not an international treaty that you need to comply with, but rather a subset of best practices that you are going to see if the country is implemented in its national legislation. And in this case, very interestingly, when we're looking at different country cases, you might find even more best practice cases that you might use in your future research. Professor Gao already mentioned the importance of understanding and mapping the norms. What are you talking about? Is it shall or shall not? Is it no party shall do something? Is it endeavor or maybe shall endeavor? All of these, I think, are carrying some weight for your research, also depending on how you are going to assess the legislation. If it's a shall provision, it's a mandatory provision, so you basically need to look at compliance. If it's a should endeavor, may clause, you might actually need to see if it exists or not, and if it doesn't exist, whether there is anything else that actually can, there is any other norm that serves the function, or even if it doesn't exist, what does this mean? What does this entail for your legal research? Once you understood your benchmark, you mapped your norms, next you are going to look at the universe of laws in a given country. Now, mind you that in some cases, looking at one law, if you are looking at a specific sector, might suffice. So it might be very, very niche, but more often than not, you're going to need a myriad of laws, regulations, guidelines to look at to understand how an area is regulated in a country. And you need to understand the scope, how far you are going to go. Are you going to look at tertiary legislation or not? Are you going to look at strategies or not? So all of these decisions, all of these ideas need to be scoped early in advance so that you can actually move forward with your research. And of course, the question of exceptions, Professor Gao already alluded to that. There are exceptions that are general. There are exceptions that are per chapter, exceptions that are per article. Even when you are not using artificial intelligence tools, it's already hard to do the research having these exceptions in mind, because you need to consider a lot of different things. When you are using artificial intelligence tools, it becomes even more complicated. And you also need to know from the beginning, are you going to look at implementation or not? Are you going to do purely desk research, so looking only at the paper compliance, or you might need to actually cooperate with national authorities, talk to stakeholders in the country, look at data to understand really what's going on. And of course, once you have all of this in mind, you start your project and you're having difficulties. I think this is unfortunately non-exhausted list. of problems that I myself faced during my career doing this type of work. And the list will depend also on your project at hand. So first of all, the problems that I'm seeing is that the differences in civil law and common law systems, in a sense that, of course, the statutes have different weights depending on whether it's a civil law or it's a common law country, because in common law countries, we also have a lot of precedents and case law that is carrying a lot of weight. Now, how are you going to look at case law, for example? How much of it you need to consider in your research? That's something to think about. And probably this can be a problem if you are from a civil law country and you need to look at common law. It might be a bit different to understand the system. There might be different international, institutional structure. In a sense that, for example, international trade law is usually taken care of by ministers of foreign affairs. So you know who would your main counterpart would be. But in some cases, it's the ministers of economy or specialized agencies. So understanding the institutional structure, who is doing what and why, is important, but it can create difficulties if you are not really familiar with the system. And of course, the web of web pages, in a sense that, of course, it's understandable that nowadays a lot of the countries have a single point of entry for all their laws and legislations, but this is not always the case. So sometimes you need to go to the websites of specific agencies and see regulation, guidelines, etc., online from their web pages. And this can take you a lot of time just to understand where to go and what to download. And if I may, just a very little solution here. If you have friends that are from different countries, if you're working in international organizations, or if you're living in international cities like Geneva, make use of the fact that you probably have access to people who speak the language and are coming from the country that you are interested in. There is no one better qualified to tell you where to find things, and maybe possibly also to translate some little elements and to give you more idea about the terminology than someone from the country. So make use of the contacts and your network. Now, in terms of operational problems, I find that lack of data is the first one that I would like to mention. Sometimes the data doesn't exist. Sometimes it's in a very patchy manner exists somewhere. And sometimes it exists, but you don't have access to it. So if your project includes implementation, you surely would like to have a look at the data and collect it as much as possible. But unfortunately, we're facing with a lot of problems here. Language barriers, they still exist, even though we have a lot of translation tools, AI translation tools. But what we are seeing is that sometimes they are not particularly well in terms of the legislative or technical terminology. And what we are finding as well is that even though, for example, the old law of a country, of a specific sector is translated into English, new laws are not, because maybe they are too new, there is no resources, etc. Or sometimes they're translating only the main law, while the regulations and the tertiary legislation that will really give the flavor of what is going on is not translated. If you have cooperation with authorities, sometimes it slows down sometimes the process, because usually countries need to have some internal stakeholder discussions before they can give you the response regarding the cooperation or validation of the results. And finally, if AI tools are used, I personally spend a lot of time tweaking the prompts, trying to get the best outcome possible for me. So, talking of AI tools, what I think could be useful if the AI tools will have for us to conduct better and more efficient analysis, I think it will be good if they could identify the laws and links more efficiently. In a sense that sometimes the tool identifies the law, but it gives the wrong web page, or for example, the web page is broken. So really, when you are going quickly, trying to get the law itself, you're facing problems. regarding the references and source accuracy as well, I still find that there are problems when you are using AI tools, because in practice, it kind of finds the paragraph you are looking for, but it's under a wrong heading, or vice versa. So ensuring accuracy and traceability of all cited legal sources is important, because you don't want just to rely on AI and then find out that it was the wrong source or it doesn't exist at all. And this is the problem of hallucination that I still find exists, even though to a much lesser degree than, say, 2 years ago. Again, the issue of legal terminology. And the problem that I find is that a lot of times the AI tools don't really find some specific provisions that are in different parts of legislation. For example, data privacy exclusions that you can find in consumer protection law usually. For the AI tools, it's really difficult to understand the human logic behind all kinds of exclusion clauses, to the extent possible clauses, for clarity purposes clauses. All of this, it's still hard for the tool to grasp. And of course, I would love to have some simpler prompts that could yield better results and to give us comparative analysis. And what I mean by this, sometimes I have to draft half a page of prompt just to get the result that I want. And that takes me, as I said, a lot of tweaking. So I would ideally like to see a simple prompt in a form of a question that actually will bring me all the results that I want, run across different jurisdictions, and give me comparative analysis. I don't know if this tool exists now or not, but I certainly hope that at some point we can have this. And of course, there should be an understanding that only through disk research or using AI tools, we will not have full 100% understanding of the implementation of the legislation on ground. So maybe I would suggest to treat this type of research as your first stage to understand what's going on, to have an understanding of the gaps, but still try to have some kind of furtherance of the project, in a sense of talking to stakeholders on the ground and maybe analyzing some data to fill in the gaps that will still inevitably be there because of the type of research that you are doing, just sitting in your office. And even if you are using AI tools, they might make it a bit more efficient, but certainly will not give you the full information necessary to do analysis. And this was it on my side. I'm happy to take questions now.
Thank you very much, Ashik. There is one question that how does the WTO currently handle scan document?
Sorry,
How in the WTO you are handle scan documents?
Scan the documents.
Yeah.
Yeah, so we have an archive that is actually dealing with all kinds of documentation. I didn't really hear anything from colleagues complaining that they cannot really use scanned documents, because for us, scanned documents are usually archival documents, and I know that people were trying to make sure that they are machine readable. But that was the information that I got. I don't know if they managed to do the project and to finish it or not. But at the moment, I don't see it as a problem, at least in the current research that we are doing.
Yes, I think the persons asked in the terms of when scan and keep it in image format. But I guess these questions can also be answered later on, because we also have Kun Sarut, which is engineer who dealing with several regulatory issues through AI-driven techniques. Yes, let me move on to our third presentations. It will be a joint presentations by two colleagues from EUI, European University Institute, Simon Gonzalez and Thomas Rockler. They are team who contribute to the DTI project, which is a large global database on digital trade regulations. Both of them contribute to consultancy work for international organizations, especially ECA, ECLAC, and also ISCAP. Thomas and Simon, please take the floor.
Hello, everyone. Thank you for the invitation. I think we need the assistance in terms of the presentation. Okay. So, as it was mentioned, Thomas and we are both working for the Digital Trade Integration Project of the European University Institute, which is this contains this database of regulatory information, of restrictions, of enabling policies of more than 160 countries worldwide. For the data collection of these policies and practices, we had the partnership with ESCAP for the Asia and the Pacific countries, and I think from our perspective, we can, from our experience, we can contribute to mentioning in this presentation how the process of data collection works, and to complement previous presentations, mentioning some problems, some limitations, some situations we encounter every single day when we do the data collection in all of these countries. When we update, when we add new countries, etc. Thomas and we joined the Digital Trade Integration Project in 2022 in partnership with ECLAC. We joined the project through ECLAC here in Latin America. We are both from the Latin American region, and then we continue working with the UI. And in this moment, we work in the update and the data collection of all the countries in the world, in partnership with all the institutions that we are going to show later. And this is why I think we can tell you from our experience some of the challenges and limitations that we find when we do this data collection. As you can see in this map, we cover mostly countries from Africa, from Latin America and the Caribbean, from Asia and the Pacific, from Europe, etc. So in this moment, we cover almost all the world, and we are trying to find new projects, new partnerships in order to continue updating and continue including new countries in the world. The next slide, please. So for the data collection, we have several steps. The first one, even though it's not specifically about data collection, but it's extremely important, is of course the recruitment. Trying to find practitioners and researchers from these academic institutions and international organizations is very important, and because this, from our perspective, we can try to find the laws, to find the information, sitting here from Latin America, trying to find this information of other countries in the world, but of course the local expertise of the specific researcher in the specific country is essential from our perspective. So this is why for us it's preferable that the researchers are based in the country that is under analysis. And this is why the partnerships with all of the institutions that you can see in the slide is so important, and the partnership with ESCAP was or is so important. So the first challenges in this data collection process regarding recruitment is the process of finding the best local researchers that bring this expertise of the legislation, the local legislation that manages the local language. This is very important, as it has been mentioned. And not only they know the legislation, but they know what is actually happening in terms of enforcement, in terms of practices, in terms of these practices that are not found in the legislation, but nevertheless they happen inside the countries, and this is key in terms, and this is why the recruitment is so important. One of the risks in this step is balancing between the expertise that the local researchers can bring to the table and the expertise that, for example, other researchers with more experience in terms of digital trade, in terms of, for example, specific topics, data transfers, foreign direct investment, etc., balancing between the experience of the local researcher and the expertise of the researchers that are not from the country but have more experience or more academic background in terms of digital trade. Please, the next slide. So the second step will be the review of secondary sources. So when we do the data collection, we recommend, and that's what we do, is try to go first to the secondary sources and not going first to the primary sources. And this is because these databases, reports by international organizations, legal reviews, government resources, and news articles, they already have analyzed the legislation, or they know more about the practices, about the enforcement, about what's actually happening inside the country. They have analyzed this, and this helps us to speed up the process, and going then, after seeing the secondary sources, going then to the primary sources and confirm what the secondary sources have already found and analyzed. And this of course gives us some it helps us to back up what we are mentioning in our database, what we're including in our database. Is not only our analysis, which is also for us very important, the analysis in our team or the local researchers, is not only that, but a second analysis that has already been done in these secondary sources. But there are, of course, as previously, there are, of course, some challenges in this step. And this is because on some of them is the limited focus on a specific policy areas. So sometimes other databases, and one of them, one that is very important is the Digital Policy Alert database. Some of them not contain all the policy areas we try to cover in our database. They cover sometimes other policy areas we don't cover. So this, of course, is a challenge because we need to then go to this database. We need to go to other databases that complement the information. Of course, another challenge is the lack of structured formats for efficient review. In some cases, some of the databases or the secondary sources that we check constantly have the information, but not in a way that we can find quickly the information inside the source because they don't follow the structures that we follow, or some of the secondary sources simply don't follow any sort of structure. They just contain information, random information, and in different ways. And of course, another challenge is some of these secondary. No, please go back. Yes, and another challenge, a very important challenge, is that many of these databases don't cover many of the countries that we would like to cover. And this is especially important in some of the least developed countries in the world. many of these databases only cover developed countries, or focus on countries that they would like to focus. So, for example, the source, the foreign trade barriers, the National Trade Estimate Report of the USTR, they cover well the countries that they would like to cover. They would like to show some restrictions in those countries. So we need to go to other databases, or in those cases, we need to go directly to the primary source, or use, of course, some tools to find information in the primary source. And one regarding the risks, in some cases, the sources may oversimplify issues. So, for example, if you would like to show in the database, in our database, you would like to show a very complex issue that you need to show different laws. You need to show enforcement of those laws, what is actually happening in those laws. Sometimes the sources just stick with one of these things. So they mention only a specific problem, or they don't mention a specific article inside the laws. They don't they simply show a part of the situation that they want to show, or they could show. So in this case, they don't only oversimplify, they also omit, in some cases, relevant information. And of course, a normal or human problem is that in some of the cases, the sources contain some errors, which we, of course, try to for that challenge, or that risk, of course, we always go to the primary source to confirm the information that is shown in the secondary source. Then please, the next slide. So, of course, the next step, it will be the review of the primary sources. So then we go to the official gazettes of laws and regulations, and in this case, of course, the obvious challenge that we find is that in some cases there is no the countries have not published the laws online. So in some cases, we have found the situation in which the law has been adopted, it has been signed by the authorities, by the president or the king, etc. They have signed it, it has been adopted, it has entered into force, but it's not published online. And in some cases, we have had to have this information with contacting local authorities, or with the help of legal experts inside the country, or in other ways. This problem, of course, as I mentioned before, is mostly found in the least developed countries, and we try to, of course, to use all our tools, all our expertise, all the contacts with the government, etc. But in some cases, the information is simply not there, or is impossible to find. Language barriers, as it has been mentioned before, is, of course, a very important challenge. So in this case, we, of course, there are many tools for this challenge. For this challenge, we try to use many tools, AI tools or other tools, but in some cases, these tools don't give you the best translation possible, or or something is missing in those translations, and that's very important when you try to code specific restrictions and specific policies. Broken links is another problem. And another problem that is very important is, of course, identifying what is actually relevant inside the laws. In some cases, as I mentioned before, the secondary sources, they contain some of the information that is inside the laws, but it's always very important to have a look at the law completely, if possible, because other articles inside the laws or sections inside the laws could be also important, or other laws could be relevant, that sometimes the sources don't take this into account. So a detailed review of the laws is always very important. And in terms of risk, something that is very common is that in some cases, some laws inside the same countries, they sometimes contradict each other, or they complement each other. So this, and in these cases, not identifying this the relevance of a law or a section in terms of another law and section could be a very important way to make a mistake doing the data collection. So can we continue with the next slide? So in terms of the time-consuming aspects of the process, of the data collection process, so when we have a new entry inside our database, we of course, and we are showing in this moment in the screen, how an entry looks inside our database. We try to find the laws. We try to find when a specific restriction policy started, when it was adopted, when it entered into force, if an amendment is important or is relevant in order for the restriction. All of these timelines are key in when we try to do the data collection, and of course this takes a lot of time in some cases, and because all of these issues have an important impact for the policies. So another time-consuming aspect of the process is ensuring accurate translation. So in some cases, we have to use several tools for doing the translation, or confirm that the translation has been done well by the tool with local experts, or with people that manage the local language. So all of these steps to ensure the accurate translation, of course, is very time-consuming. And as something that's very important, and tools are now very helpful for this, is the loss of access. Is the loss of access to previously verified links. So we try to use some tools in order to save some of the links that we have seen. We save those links using different tools, and but in some cases is that not even that is possible, and that takes, or quickly, and that takes a lot of time. And sorry, can you give me a second? And another important aspect of this process is that for trying to avoid mistakes, we try to use several steps, human steps, to avoid mistakes. So for example, I can have a look at the laws. Then Tomas, for example, can also have a look at the same laws or same reports, and all local researchers. And all of this cross-checking is very important in order to avoid mistakes. And that is also time-consuming. Every tool that can help in this process would be amazing. Please, the next slide. So in terms of time, I think I'm going to go in this one very quickly, because Tomas is going to expand more into the information of tools. But I think, as I have mentioned, the tool for identifying the information in the primary and secondary sources is very important. AI tools or the other tools, this is very important. In terms of the readability of the documents, using tools for scan PDFs is essential. In some cases, it's impossible or very time consuming to read these links, which scan PDFs, read it completely without the help of a tool or without the help of a local researcher, and this is essential. Um, uh, and one of the I'm going very quickly. So for the limitations, in some cases there are no tools in our disposal or available in the market to support all of what I have mentioned, and this is a problem we have found very frequently. And or also, of course, a limitation is the knowledge of how to use these tools effectively. And of course, many of these tools are very recent in the market, and it's a process also to learn how to use them. Is takes some experience, takes some time, but it's very important for the data collection process. This is the next slide. So the final challenges and limitations that we have found is the exponential growth in regulatory activity and frequent amendments and replacement of legislation across countries. Of course, all of these changes that countries do in terms of their legislation is very problematic for the data collection process for the researchers, because you need to constantly update the database, and for as you can imagine, for more than 160 countries, this is a very time-consuming process, or that needs lots of work from different researchers. And it's not only that there are new laws or new amendments, it's that digital trade legislation worldwide is becoming more and more technical, more and more complex. Countries frequently try to impose different types of restrictions in different ways. And this, of course, is a challenge for the researchers. As Yasmin mentioned before, sometimes the governments, we sometimes need the help from local governments or local researchers, people with local expertise, but the feedback is not always there. So this is, of course, a very important challenge. And in terms of and it's very important to have this help from the local experts, because in some cases the laws or the practices are not the same. They have the same impact, but they are not exactly the same. In if When you see the laws, when you see what they actually do inside the countries, they don't always do the same things in those different countries. And another problem is that there is limited consensus among the different countries on how to classify if this is a restriction, if it is not, if it is an international good practice. All of this is a very important problem for the process of data collection. Thank you very much. Thomas.
Thank you. Well, now with this broad, comprehensive picture that Simon has given, and also the other presentations, I will move to the more general stage to focus on what tools will be needed to produce regulatory research that is faster and more reliable. So at this stage, the key issue is not only whether AI can help us to find legal information, but the more relevant question is whether the tool can transform that information into regulatory evidence. With this, I mean a documented record linking the regulatory measure to its legal source, provision of text, translation, timeline, and the methodological relevance. If so, this regulatory evidence needs to be structured, comparable, and auditable. Otherwise, the tool may save the time at the search stage, but can create new problems at the review stage. In practical terms, the output must be aligned with the methodology followed, and for our case, this should, among other things, identify the country, the relevant pillars and indicators, the legal instrument, specific provisions, dates, among other things. So to ensure that an AI tool is useful for comparative regulatory research, I will focus on three essential elements: format, citation quality, and language coverage. The first element is format. So once the tool finds a relevant law or regulation, how should it present that information so that the researcher can verify and use it in a proper way? Among the must in format, information must be structured, must be machine readable, and compatible with the software you are using for your research. In this sense, for the database like the DTI, a paragraph level answer is not enough. The tool should produce outputs that can be directly reviewed and compared by the researchers. And with these outputs that can be directly reviewed and compared, I mean that findings should be broken down in different fields. For example, in the case of the DTI or the Regional Data Trade Integration Index, the tool should separately identify the country, the relevant pillar indicator, provisions, as I mentioned, the source, date, and likewise, it should include flags of uncertainty, missing information, contradictory sources, and possible amendments and repeals of the different laws and regulations. This matters because comparability depends on a structure. If two researchers receive unstructured summaries, they may code similar measures differently. But if they receive the same type of evidence in the same type of format, the review can become faster and more consistent. Yes, 3 minutes. Thank you. Next slide, please. So the second element is citation quality. When we get a structured output, how we ensure that this one is auditable for researchers and for the general public? In regulatory analysis, a generic citation to a law is rarely sufficient. If the tool says that the country has a data localization requirement, for example, we need to know exactly where the requirement is located. Is this in a statute, in an implementing regulation, in a decree, or is in a specific sector guideline? This is particularly relevant because secondary sources, as mentioned Simon, may refer to a legislation, but sometimes the specific provisions, the dates of which these measures apply are not included. As well, when using primary sources, they may contradict, complement, or modify each other. A law may establish a general rule, while a decree, guideline, or sector regulation may define the actual compliance obligation. For this reason, the tool should not only cite the document, but also identify the exact article, section, or paragraph with the enforcement states and amendments. Good citation quality is what makes the output auditable. The researcher should be able to move from the proposed classification back to the original legal source quickly and transparently. The third requirement is language coverage. Please, next slide. Although many countries have next slide, please. Although many countries have adequate translations of their laws, many of the most relevant legal sources are not available in English in countries where English is not the first language. Therefore, if a tool relies primarily on English language sources, it will replicate existing coverage gaps and may overlook precisely those countries where support is most needed. However, this does not mean that researchers should rely only on tools given by AI translation. Ideally, the tool should provide a reliable translation, but also retain the original legal text and indicate the relevant provision in both documents. This is important because legal meaning often depends on specific terms, institutional reference, or drafting conventions, and in this regard, it is essential to verify and compare the provisions of the translation in both of the texts, the translation and the original one. Ideally, the tool should also flag uncertainty, and for example, if a term has not clear legal equivalent in English, or if the translation depends on a context, this should be visible for the reviewer. And finally, next slide, please. Once the tool has produced those output, how should the researcher use them? AI can accelerate the preparation stage of regulatory research, but final verification, interpretation, and coding must remain with the human researchers. In comparative regulatory work, the most difficult part is often not finding a document, but deciding how this document fits in the methodology. For this reason, the strongest contribution of AI would be to reduce the time spent on discovery, extraction, and citation, while keeping human researchers responsible for the final validation. Thank you very much.
Thank you very much, Simon and Thomas. I saw questions in Q&A, but I think to save time, could you please write your answer in the Q&A chat, because they direct those questions to you.
Sure.
Let me move on to our last speaker, Kun Sarut Titsena. He has more than 20-year experience in tech sectors. He was working as former deputy MD in Microsoft, and the most interesting part in his profile would be he has bring both engineer and regulations together in the projects of Thailand to OECD, that he used Gen AI and GraphRack to align the Thai laws to OECD standards. Kun Sarut, please share your experience with us.
Okay, thank you, Kun Vithadan. Good morning, good evening, good afternoon, everyone in the session. To be very honest, I'm very excited. I'm the engineer in the room. So I'm not going to have a slide to talk to you about regulations, how to define the laws, etc. But I put up my presentation as an engineering lesson learned on what we have done recently in Thailand, and what I believe it might be relevant to those technical people in the session who might need to develop a certain AI system to address this hackathon target, I would say. So let me bring up my slide. Okay, can you see my slide properly right now? Okay, I hope it's all good. That very colorful slide.
Yes, we can see.
Yes. So briefly introduce myself again. I'm Sarut. I am the Chief Technology Officer from a company called Intelligence. We're based in Thailand. We've done a lot of work of LLM related application development, supporting most Thai customers and some regional customers as well. In terms of who we are and what my presentation is all about, we won a Microsoft AI Partner of the Year award for Southeast Asia in 2024 with that particular project that the Vice President of Microsoft, Mr. Brad Smith, has shared on his LinkedIn 2 months ago. So basically what he said, I just want to read what he said. Thailand has done something that the OECD has recognized as the first and inspirational example for the world. And that project is called TH to OECD or Thailand to OECD. That's the project that we done here. I'm going to spend some time to explain what we have designed the system. And then I'm going to wrap this up with what exactly do we learn from the engineering practices. I have to say that there's a lot of ups and down moment going through this massive project. Yeah. So Thailand to OECD, for those of you who are interested, you can visit this website. It's a website from Thai government, which basically in a nutshell explaining our process of joining OECD. And I'm nervous. I'm with lots of lawyers in the room here. But basically, in order for a country like Thailand to join OECD, we need to perform we need to go through what they call an accession process, which basically means that we need to look into every single legal instrument in our country and get back to OECD and tell OECD how aligned our legal instruments are according to the legal instrument from OECD. It sounds simple, but in reality, we're talking about more than 270 legal instruments from OECD side, and then more than 70,000 legal documents in Thailand. So we need to do that cross-referencing. We end up analyze more than a millions of legal provisions over the past X months. And what I want to call out is, this is a picture of the output of the system. So back in December 2025, I think the OECD team has come to meet Thai government. That's the Prime Minister. We basically submit the initial memorandum to OECDs, and that more 1,000 pages of memorandum is AI generated memorandum. So that's what exactly what Brad Smith has mentioned, that this is the first time where OECD accepted AI generated documents. So that's what we've done. So in a nutshell, as I said earlier, we processed 70,000 legal Thai documents, around more than a million of sections, depending on how you define the sections of the regulations. Usually this process takes about 7 to 10 years for those countries who already joined OECD. Thailand has very ambitious target that we want to speed up the accession. So we make it 11 times faster. So in total, we have done this project for, I think, for about 15 months, give and take, from the beginning of the project until the day that we hand over the initial memorandum report to OECD. So there are 4 major challenges that this system will need to address. Number 1 is, as the previous presenter mentioned, the language. So OECD instrument is in English. Thai legal instrument is obviously in Thai. So we're going to need to process the cross-referencing of these 2 sets of documents in 2 different languages. And then we need to be able to identify one OECD instrument, usually touch about 30 or 50 different legal instruments, which you will see later. And then there's a lot of many-to-many legal mapping that we need to identify and cross-reference as well. And most importantly, as every presenter before me mentioned, that how do we do this with human in the loop at scale? Because we're not going to say that, hey, AI, let's do this job and we will take it for granted. So we put human in the loop in every single step possible. So that's kind of like the 4 big challenges when we design this project. So here's how the design looks like. First, since our end user is OECD themselves, so we need to uphold the AI principle of OECD. But specifically for this project, the top 3 principles that we need to really focus on was transparency, security and safety, and accountability. Obviously, because we don't want to treat AI as a black box. And this is how the overall project looks like. So when we receive an OECD instrument, we need to answer this question. Number 1, how can we translate the instrument from English to Thai? Then we need to be able to understand what this instrument is all about. What does it regulate? Once we identify the content or the gist of that particular instrument, then we need to identify which Thai legal documents relevant to this particular instrument. And then we need to identify the alignment level of the Thai law versus OECD requirement. And then we identify which government agency who is responsible for this a particular piece of instrument. And then we need to identify the gaps, where the gaps are between Thai instrument and OECD instrument. We combine everything and serve the analysis to the human lawyer, where human lawyer will review all the AI recommended or AI suggestion. Once we took human lawyer feedback into the system, then the AI will summarize it again and finally generate the output back to OECD. So that's how the total complete picture looks like. As you can see from the color on the screen, we put human in the loop by design on lots of places because this is more like a state gate where every single step before you pass to next step, you need to be able to, certify by human lawyer. So that's how we design this system. One thing I want to call out is for those of you who plan to design a system that need to be able to scale, you need to think through very deeply about the workflow like this. Depending on the current workflow that the human operates and the future workflow that you will develop AI to serve the needs. Because the earlier you can identify the workflow is the better you will decide, okay, this is where we're going to put human in the loop as the governance gatekeeper. You can't do this at the late stage of the design. And if you don't do this early in the game, your system will not be able to scale out properly. For example, at the beginning of this project, we have a discussion where, hey, should we do a chatbot or can we leverage Microsoft Copilot to do this work? The answer is no, because this is just one OECD. We got 270 more OECD instruments coming in. And then the human lawyer on the right-hand side, we're talking about 65 up to 70 government agency in Thailand across the country. So with that scale into the picture, you have issues about, how can you standardize the process, how you can ensure everyone write the same prompts, how you can ensure everyone read the same languages coming from the system. So a lot of variation is going to happen if you build this as a chatbot. That's why we decided that, okay, this is not going to be a chatbot. This is going to be a workflow-based application. So that's kind of like what you need to bear in mind very early in the game. The second part is the translation that lots of people mentioned already. So this is what we have done on the AI translation engine when it comes down to English versus Thai. So basically, the key thing is here. We develop a legally approved glossary, and then we keep that glossary as part of the skill MD for the AI agent. So the job of the AI agent is to A, read and understand the context of the legal content, and B, pick the right words, and C, surface the word that the AI picked for the human lawyer to approve. A classic example is the term public. Public means so many things in Thai. It can mean satharana, which is public. It can mean ประชาชน which is people. It can mean there are 6-7 different ways to translate public from English to Thai. So that's the trick that we have used in this project. Another part for translation that you might want to look into is dates. For the English-speaking country, this might not be an issue, but for Thailand cases, we use different calendar as compared to you. We're not using Gregorian calendar, so we need to do a date conversion properly. And also, strongly suggest all of you to discuss about the format of the date at the beginning of project. Are you going to go European way or US way? That will impact a lot on your code. So discuss that earlier in the planning. And here comes the selection and the mapping part. This is going to be quite complicated, but basically we leverage generative AI, the LLM capability to perform semantic matching, which is basically mapping all possible terms and terminology that can match between two legal instruments. Take data privacy, for example. For data privacy in the English semantic terms, at least you have 5 different semantically similar terms there. In Thai, for those of you who can read Thai, this is all 5. And for Bahasa, those of you who can read Bahasa, that's also another 5 terms. So this is I would say, a spider web of what could be potentially related to data privacy term. So this is where we leverage generative AI to perform the what we call semantic matching. Once we can perform a semantic matching, what we've done again in this project is to construct a legal database that has multiple layers. You heard a lot from the previous professor that mentioned about, in the digital trade domains, there are hierarchy of the legal paper, etc. We do the same for this OECD project, where we basically construct a database of Thai legal instrument based on the section, the legislation, up to the notification and the rules. And then we build a spider web using a technique called graph rag, so that we have this database for the AI to crawl with very high accuracy. So that's why we build this database. At the end of the project, we achieved this chart. For those of you who are legal professionals, you would understand this pain point. One legal instrument for this case, this is integrated mental health skills and work policy, usually related to more than 20 or even 30 legal instruments for the domestic countries. So this is what we build for this project, where you can run a query on the spider web of Thai legal database, where you can pinpoint and identify which particular acts, which particular directive, which particular ministerial regulation related to what on what specific area, and how that all up link to that OECD instrument on the left hand side. So that's this is the outcome of that project. Once we have this, everything else is simple. We get the lawyer in the room to review each and every pieces of the identify instrument, take the lawyer comments and put it up into initial memorandum report. So that's basically the gist of what we have done for Thailand OECD. So what have we learned, or at least what I have learned from this OECD project? Number one, I would suggest that impact equals to these three pillars. So when you design the system of this hackathon part, I strongly advise you factor in these three lens of looking things. The first one is the workflow. How do you design the workflow? How do you automate the workflow? Is it possible to do so? What's the current workflow looks like, and what's the future workflow should look like, where the human will be in that workflow and where AI will be in that workflow. Workflow design is crucial because you're not going to end up telling the user that, hey, go use ChatGPT or go use Copilot. That's not going to sustain, because you likely going to have more than one user, right? The second one is the governance and the agents. As everyone knows, agent these days. How do you plan to govern the agent, etc.? That's the second part of the design that you need to really look into. And the third one, just like my previous presenter very greatly mentioned about data, the output that coming out from the system need to be in a structured way. How do you plan to have the structured output coming out? How do you design all those fields? That's the another area that you need to look into. So I want to touch a bit on the topic of governance and the AI agent. I think everyone talks about AI agent, right? And for those technical team in the room, I want to highlight that AI agent is what we call technically as a heuristic system, which is basically the nature of generative AI, where it uses the probabilistic model to identify, extract, classify, process data set that coming in. There's a pro and con of this system. We all know that generative AI these days is the good stuff. That's why we all here. But there's a draw side of the nature of the heuristic system as well. For example, everyone always asks me that, Kun Suruj, how do we build a system where you run the system twice and it gives you the same result? The answer is no, you cannot expect that from a generative AI system. If you expect consistency, you need to have another system baked into the same solution. Another system is what we call deterministic system. So basically, it's a system where there is no randomness. 1 + 1 is 2. 3 plus flow is 7, as always. It's going to be fully predictable behavior. There's no random. It's pretty much rule-based. And guess what? Everyone know this as Python. So my point is, when you design your system from an engineering standpoint, don't only use prompts. Because if you only use prompt and you say, hey, let's Claude Cowork do this, let Copilot Studio do that, you're going to end up to have so many randomness in the system, and eventually you can't scale it out. So you need to think about which part of my workflow is going to be heuristic and which part of my workflow has to be deterministic. Because any part that you expect consistency, repeatability, you need to have a deterministic system, rule-based system, not a heuristic system. On the other hand, if that part of your workflow require, some nuances of legal interpretation, language differences, you're going to need to rely on heuristic system, not Python. Think about how to identify 5 different ways to say data privacy, versus if you want to do a calculation, don't use LLM to calculate for you. You can simply write Python for 3 lines of Python. You can do the calculation much simpler. Okay, so that would be my very, very strong recommendation when designing the system. Another one, and I intentionally put this in a funny way, the governance. So everyone talk a lot about how to govern AI, how to automate, how not to automate. Where do you put human in the loop? My response to that is there's no single answer to all those questions. It all depends on the project. It all depends on how you design the workflow, and it all depends how you interact with the user. I think it's more of an art than a science. For example, anyone who watched football like me would remember this photo. This is for those of you who don't watch football. I'm sorry, but this is the scene of what we call the hand of God, where Diego Maradona just did the handball. Back in those days, in the football field, there is no what we call VAR, the video referee. So the referee did not catch that. Eventually, that handball was accepted, and eventually Argentina got that score. This is a case of back at those days in the game of football, there is no oversight, which means there's no friction. Every movement, every turn, all the games are played quite continuously. But for those of you who watch football these days, we have video. And the video, it has pinpoint just like a small fraction of the offside of the players. So it turns out that these days in football game, we have so many oversight, lots of friction, there's less automation. So in your system, when you pick up, how much automation that I should put in, or how much oversight I should put in, think about these 2 extreme scenarios. No oversight is bad, but too much oversight is also bad as well. So you need to find the right balance. I think that's what I'm trying to convey with this scenario. Lastly, I have summed up 5 key principles when designing a generative AI system, at least from my experience dealing with legal tech and lots of regulation. Number 1, I think most of you technical people in the room would already know this. In every AI system, you need to have multiple iterations. You cannot expect the first version to be perfect. So your first version will just be okay. And then you continue to improve from your first version. And in order to do that, you need to identify first that what good looks like. Where do you want to go? Where do you need to be? What accuracy level that you need to match? What does it mean match? What does it mean good? How do you define good? I think that's the core. Because once you define what good looks like, then you can build the first version. Then you take feedback and iterate and reiterate toward the North Star of the project. So do not start the project without a clear definition of what good looks like. So that's my first lesson learned. First principle. The second principle is once you define what good looks like and you understand the nature of AI project where you need to build multiple iterations towards what good look like, You need to build observability early in the game, meaning that you need to have telemetry monitoring, you need to have intermediate result monitoring, you need to have version control, you need to have a run log, you need to have a log file. Anything that you can capture as a telemetry of each run will help you iterate much faster. In normal AI project, I have never seen any good AI project that finished less than 3 iterations. So think about it. If you need to run this AI project at least 3 times, do you have enough log to improve it on the second and the third iteration or not? And in order to have a good enough logs and telemetry, you need to design the observability very early in the game as well. That would be my recommendation. The third one is domain grounded reasoning. I think I've been listening to all of my previous presenter, and I'm very enjoying. I guess what I'm trying to say is, for those of you who are AI engineer, you absolutely cannot work in a legal and regulation domain without a very close collaboration with the legal and the regulatory expert. For example, is data storage the same as data processing? From a legal standpoint, no, right? But how do you define that in your prompts? How do you teach your AI to distinguish that differences when it comes to not just a word, but the interpretation of the word? Or another example is, if there's a regulation where you mandate a company to have a local registration in the country, does it mean a national discrimination? I don't know. And if you don't tell AI, the AI will make its own assumption. So you need to collaborate and work very closely on the definition of this is what it is, this is not what it is, with your legal expert in order to teach the AI with the right mindset or the right lens. I mentioned this already, that eventually you need to have a very clear boundary between AI and code. The LLM is very good on semantic meaning, addressing ambiguity, reading human language, performing comparison, etc. But when it comes to validation, counting numbers, checking if the field is corrected, performing version control, scoring something, package the output in a structured way, I always use code, not using AI, because I need consistency. So in the end, it's up to you. How do you define, this is what we need consistency, and this is where we need, all the nuances approach. Lastly, when you design this system, you heard from my earlier presenters as well that we're not talking about one country, we're talking about multiple countries. And we talk about not just one domain, but multiple domains as well. So you're going to need to design where the system should be generic and where the system should be specific. If you design the system to be too generic, you will not be able to handle many things that's specific to that domain. On the other hand, if you design everything so specific, you can't scale out. You can't like, hey, I build this for Thailand law, for Thai law, and you want to replicate this same methodology to address Malaysia law. If you make it too specific, you won't be able to do that. So you need to, design your system. Again, it's more of an art than science. Don't make it too generic or too specific. You need to identify the right layer of this. From my experience, specific design will comes up when it comes to the repository of the legal document that you need to handle. For example, in Thai website, we have our own way for the date formats. But in Singapore, in Malaysia, they will have different way to address the date. And if you need to identify, is this provision still in effect or not? Your AI must understand the different format of different countries in writing the dates, right? So that's one of the specific design to each of the country. But when it comes to generic, you need to be able to generalize that these are the area of cybersecurity, these are the areas of data privacy, etc., etc. That's the general part that you should look into. Lastly, I just figure out when listening to my earlier presenter, I think in this specific hackathon, finding the finding the laws or the instrument is, I wouldn't say simple, but it's straightforward. The difficult part for all of you in this hackathon is finding the no, not the yes. For example, you're gonna have a case where is Thailand have local requirement or not, right? You're gonna need to find a law that define local requirement. But if you want to find does Thailand has a ban on XYZ, you need to find the whole universe, search the whole universe, just to confirm that no, Thailand doesn't have that ban. So think about, are you searching for a yes or are you searching for a no? That's gonna require a totally different search logic. That would be my last recommendation. I'm sorry, I think I over the time a bit, but I hope this is useful to all of you. Thank you,ครับ.
Thank you very much, Kun Sarut. I believe that many of our participants today are engineers because I saw many questions direct to you and they feel very into what you are talking about because they are solving quite similar things.
Okay.
I saw the questions with there are practical questions and there are kind of career questions that you may be interested to answer. Start with practical questions. They ask whether you use off-the-shelf LLM in your framework, in your OECD projects or not.
Yes, in OECD project, we partnership with Microsoft. So we leverage Azure OpenAI model for that particular project. We start off project with GPT-4o just because back at those days we don't have GPT-5 yet. Turns out that GPT-4o was quite okay, but obviously it's not as good as GPT 5.5 these days. So short answer is in that particular project, Brad Smith proudly present that project. So it was Microsoft model.
Yes, definitely. And there is the questions about did you use RLHF? I believe it's reinforced learning.
Unfortunately, specifically for OECD project, no. For those of you who don't know, RLSF is basically a feedback loop where we train AI to understand the world, and then we continue to train the AI to understand more of the world. We don't have that luxury for that OECD project because we only have 15 months of the workflow, of the total workflow to complete. So we only have a few iterations where we work with the lawyer on the translation, and then we use a few short prompting techniques and graph rack to ground AI to give an accurate answer only. So we didn't have a chance to do RLHF. If I could go back in time, yes, I want to try that technique as well.
And the other question is about how did you collaborate with the Thai government on the OECD projects? This would be very interested to replicate in other countries such as Indonesia because they are into OECD as well.
Right. Again, to be very transparent, we as the local company was introduced by Microsoft to the responsible agency in the Thai government, which is the Office of the Council of the State. For those of you who doesn't know, the OCS or Office of the Council of the State is the more of a legal house for a legal house for the Thai government. They're responsible for drafting pretty much 80% of Thai laws, and they're responsible for interacting or interfacing with OECD. So basically, they are the project owner. So we work with the project owner. So the project owner will have the authority to collaborate across Thai government agency. That's how it works. I didn't have a big team to engage with 60 different government agencies. I only have one team that engaged with OCS, and then OCS helped me engage with all other agencies altogether.
Thank you very much. No other questions to Kun Sarut right now, but I believe that, just when I say there are one more coming. The question is, we use GraphRack for our project. did you propose for your project to the Thai? What approach did you propose for your project to the Thai government?
What that question actually means? Sorry.
He said we use GraphRack for our project for amendments, notification, updates in the future. What approach did you propose for your project to the Thai government?
Okay, I don't know what you mean approach, but basically, by the way, I'm so happy to hear this. Yes, we living in the same painful world. For those legal people in the room, the way that all of you wrote the amendment updates is very painful for an engineering like us. So, and by the way, that's how Thai legal instrument was written. So there's a main provision that doesn't change over 10 years, but there's a lot of change in the annexes or attachment to that provision basically every year. So the typical rack won't work. The skill, the concept of agentic skill doesn't work because we're talking about huge context window need to process all at once. So eventually we end up with graph rack technology. We propose to the Thai government that this is the technique that we're gonna address. We actually build a prototype for a traditional rack versus a graph rack just to show to the Thai government that this one has much higher accuracy. So let's go with this one, please. And that's how we get the approval.
Thank you very much. I believe the conversation will still continue, and probably I will get more questions to email to you, Khun Sarut. Today we have very interesting four perspective, and I gather from Professor Henry Gao from SMU that law has precise language. There are hierarchy application types that matter for interpreting the law correctly. So that is to be first order conditions that the tool has to address. And then Ashik from WTO has shown us what the real policy community would need from the AI tools. We learned from Simon and Thomas from EUI about where data collection by human breaks at scale. And there are suggestions on which lists that they want from the AI tool to help them solve those issues. Last but not least, Khun Sarut has tell us that all those complicatedness, although it's look hard, but actually it's achievable, and he has proved it through his real projects on Thai to OECD. I thank you very much to all four speakers of ours today. We have not end the conversation here. We still have tomorrow and next week webinars. Tomorrow we will have closed sessions for specifically for our hackathon participants. There will be hands-on exercise waiting for you. So I'm sure that it will be deep learning happening tomorrow. And then next week, we will go deep into technical aspect that you may interested and take some lessons, learn some tricks to use in your development. Until next sessions, I thank everyone for your attention and see you again. Give our speakers a big round of applause, please. Thank you. See you. Bye-bye.
Thank you. Bye-bye.
Thank you. Bye.
Thank you. Bye bye.
Thank you. Bye.
Thank you. Bye bye.